Hi there, everyone. Thanks for coming to virtually coming to this presentation today on eviction moratorium updates. And I want to first start by saying I have a wild cat that keeps jumping onto my lap, so I apologize for that. I don't, anyway, um, don't be distracted by the cat. I'm a partner at Farella, Braun, and Martel. I'm the head of our business litigation practice area, and a lot of my practice involves real estate litigation, and particularly during the past year, that's been true. And there have been a lot of landlord-tenant issues, actually, unsurprisingly, that have come up during this past year that we've been in this pandemic life. And one of the things that has marked this time period is that there have been a number of eviction moratoriums that have, of course, been enacted by governments at the federal, state, and local levels, and they've changed a lot. There's been a lot of evolution of those. So I've done a few programs like this over the last year, and it seemed like it was time to do a new one because there have been some recent changes that people may want to know about. So if people have questions, I want to encourage you to ask them. There will be time at the end for questions, but if something comes up during the course of the presentation that you want to ask, feel free to do that as well. Anyway, with no further ado, though, why don't we get started? So there are going to be three parts to the presentation. The first is going to cover SB 91, which was California's recently enacted eviction moratorium and rental assistance law. The second part will cover commercial eviction moratoriums, which are all at the local level. SB 91 does not cover commercial tenancies. It only covers residential tenancies. So the commercial moratoriums are all at the county and city level. And then there also is a federal eviction moratorium that's in place as well. So I will briefly talk about that. But let me start by talking about SB 91. It was signed into law by Governor Newsom on January 19th. It extended the prior moratorium that California enacted last year, which was AB 3088. It extended that through June 30th of this year. And like I said, it is residential only. It does not apply to commercial tenancies. And it also preempts local residential moratoriums because, as you probably know, there were many locally enacted eviction moratoriums that came out of many cities and counties in the early days of the pandemic last year. So those are all preempted by AB 91. The basics of, SB 91. The basics of the SB 91 moratorium are as follows. For the time period from March 1st of last year to August 31st of last year, a tenant cannot be evicted for non-payment of rent during that period of time if the tenant declares financial hardship due to the pandemic. For the subsequent period of time, starting on September 1st and extending through June 30th of this year, a tenant can also not be evicted for non-payment of rent if the tenant declares financial hardship due to the pandemic and pays 25% of the rent that is due during that time period. And I put in bold and italics here what that means. It means that 25% can be paid anytime through June 30th, 2021, including in a lump sum on the final day. And if that payment is made by the final day, even if it's payment for 25% of the entire time period going back to September 1, then a landlord cannot evict a tenant in that circumstance. And I add this last point here, which is that even if the tenant cannot pay the 25%, if the tenant declares financial hardship due to COVID, the landlord cannot commence any evictions until July 1st when the moratorium expires. Now, landlords can still evict for just cause reasons like nuisance, for example, but at least through July 1st, a landlord cannot file such an action as a retaliation for the tenant having COVID-19 rental debt. Basically, you can't use that as a pretext for trying to, right, or as an end around if a tenant has not paid their rent and has declared financial hardship due to COVID. Beginning on October 1st, landlords can go to small claims court to recoup unpaid rent for time periods between March 1st, 2020, which is basically the beginning of the pandemic, and June 30th, 2021, which is the end of this moratorium. The statute, SB 91, has actually waived the jurisdictional limits of the small claims court to allow for the small claims courts to hear those claims. Typically, small claims court has a $10,000 limit for claims by individuals and a $5,000 limit for claims by entities. Those have been waived for rent collection actions that will start on August 1st. Also, as part of SB 91, landlords are not permitted to charge late fees or interest for non-payment of rent for that pandemic time period starting March 1st, 2020, extending through June 30th of 2021. SB 91 also has a rental assistance component in addition to the eviction moratorium. And the rental assistance component was made possible by a very large infusion of cash that came from the federal government, $2+ billion. And the way the rental assistance works, the way the rental assistance component works is landlords have a choice whether they want to participate or not. If a landlord participates, then the state will cover 80% of a qualifying tenant's unpaid rent for the time period from April 1st, 2020 through March 31st, 2021, so long as the landlord forgives the rest of what is owed and does not pursue an eviction. On the other hand, if the landlord declines to participate, the state will cover 25% of a qualifying tenant's rent for the same time period. And that, in theory, would allow the tenant to avoid being evicted under the eviction moratorium. So essentially, landlords have a choice to make with respect to any given tenant if this issue comes up. And clearly, the state is trying to encourage landlords to not evict. But on the other hand, they've given the landlords the option to opt out, and that may be an appealing path to go down if a particular tenant seems like they're unlikely to be able to qualify or to use the 25% to actually pay rent or for other reasons. So anyway, it's an interesting decision, though, that has to be made in certain circumstances. I'm going to shift gears now to commercial moratoriums. Like I said, the state moratorium does not apply to commercial tenancies. However, Governor Newsom has signed a series of executive orders that authorizes local governments to enact commercial moratoriums. And there had been a March 31st, 2021 deadline at which time Governor Newsom's prior executive order was going to expire. He has now extended that in an order dated March 4th. And so the authorization for local governments to have commercial moratoriums is extended now through the end of June. So I'm going to talk about commercial moratoriums in several of our local cities and counties. And you'll see they're all a bit different. So I'm going to start with San Francisco. San Francisco's commercial moratorium, first of all, it applies to any commercial tenant or subtenant, including nonprofits, that A, are registered to do business in San Francisco, and B, had combined worldwide gross receipts of 25 million or less in tax year 2019. And if a tenant qualifies under that standard, then the tenant or subtenant, if they missed a rent payment between March 16th, 2020 and June 30th, 2021, due to COVID-related financial impacts, the landlord may not evict for non-payment. And for purposes of San Francisco's moratorium, a tenant who subleases is considered a landlord vis-a-vis their subtenant. The San Francisco commercial moratorium, interestingly, does not cover a tenant or subtenant that occupies space in a property zoned or approved for office use, unless the tenant or subtenant is a nonprofit with valid 501c3 status. So nonprofits with valid 501c3 status are actually exempted from that limitation, which otherwise is a pretty significant limitation on the commercial moratorium. It also does not apply to tenants or subtenants of the city and county of San Francisco. And then in addition to the sort of the basic rule that I stated a moment ago, after the moratorium ends on June 30th, there's a forbearance period that applies to tenants who are covered by this rule, in which they're given extra time to pay back missed rent before they can be evicted for non-payment. And the time the time of the forbearance period varies depending on the number of full-time equivalent employees a tenant had as of November 1st, 2020. And as you'll see in a second, the rule actually splits tenants up into 4 tiers. Tier 1 tenants are those that have 10 or fewer full-time employees as of that date in November of last year. Those Tier 1 tenants get a 24-month forbearance period before they can be evicted for non-payment of rent. And effectively, that means that they could not be evicted until presumably June of 2023. Tier 2 tenants are those that have between 20 and 24 full-time employees. They get an 18-month forbearance period. So that would go until sometime in the fall of 2022. Tier 3 tenants are those that have between 25 and 49 full-time employees. They get a 12-month forbearance period, so basically until June of 2022. And then actually, back up, when I said Tier 2 tenants would get until the fall of 2022, I actually meant the end of the year. It would be December. Sorry about that. And then Tier 4 tenants, which are those that have 50 or more full-time employees, do not get a forbearance period. So once the moratorium is up at the end of June, Tier 4 tenants would be subject to eviction if they can't pay back rent that was missed during the existence of the eviction moratorium. San Francisco also allows Tier 1 tenants to actually terminate their leases early if they are unable to pay rent due to COVID-19 related financial impacts. That's a pretty big benefit actually for Tier 1 tenants. In addition, commercial landlords might be able to recover possession early, that is, evict a tenant before the forbearance period is over if the landlord owns less than 25,000 square feet of gross floor area and can demonstrate that a significant financial hardship is created by the inability to evict. And to be clear, this last point is important. The moratorium does not relieve a tenant from liability for unpaid rent. And it also does not prevent a landlord from seeking to recover rent owed simply by filing a lawsuit for the recovery of unpaid rent. as opposed to evicting a tenant. I'm going to talk now about Oakland's commercial moratorium. Oakland has a commercial moratorium that's somewhat different from San Francisco's. It covers small businesses as defined under Government Code Section 14837D and nonprofit organizations. Section 14837D has the definition you see here for small business. It means an entity with fewer than 100 employees, average annual gross receipts of 15 million or less, and a principal office located in California. So it's a little more restrictive than San Francisco's moratorium, at least in terms of the financial qualifying factor. And one thing that's interesting about the Oakland moratorium is the way it's written. It, by its terms, it would cover all nonprofits, regardless of whether they satisfy the small business definition or not. So if you take it at face value, presumably even an organization like Sutter Health, which is certainly doesn't meet the small business definition, would enjoy the benefit of this moratorium, which seems like an odd result. And I have to think that maybe there was some sloppy drafting involved in that. Under the Oakland commercial moratorium, a covered entity cannot be evicted for failure to pay rent if the non-payment was caused by a, quote, substantial decrease in income, including but not limited to a decrease caused by a reduction in hours or consumer demand caused by COVID-19 or the governmental response to COVID-19, and it has to be documented by the tenant. And the Oakland moratorium now extends through June 30th, 2021, pursuant to Governor Newsom's executive order. And again, like the San Francisco commercial moratorium, it does not relieve tenants from liability for unpaid rent, nor does it prevent a landlord from taking action to actually recover rent that is owed. It just prevents evictions. Santa Clara County also has a commercial moratorium, and it has an altogether different definition of who is covered. Santa Clara County, in contrast to Oakland and San Francisco, bases its definition on a federal regulation, in this case, Federal Regulation 13 CFR Section 121.201, which is the regulation that governs U.S. Small Business Administration loans. So you basically have to qualify under that regulation as a small business in order to qualify for the Santa Clara County commercial moratorium. And in the second bullet point here, I've shown the link for the SBA website, where it explains these, what they call size standards that entities have to meet in order to be considered a small business. And they vary by both by industry and based either on the number of employees or the annual receipts of the business. And this website page actually has an incredibly long chart. The SBA really breaks things down in a pretty granular manner by industry, employees, numbers, annual receipts. That is how the city of Santa Clara has. Sorry about the cat. That is how the city of Santa Clara has done this. And it does apply to nonprofits so long as they meet the small business definition under the federal regulation. The Santa Clara moratorium extends until April 30th, so it actually is a little shorter than the others that I was talking about. And the Santa Clara moratorium, the way it works is if a qualifying tenant has suffered a substantial loss of income or a substantial out-of-pocket medical expense as a direct result of the pandemic, then they can delay their payment of rent specifically, they can delay payment by 6 months until 6 months after the end of the moratorium. They can repay 50% of the past due rent that came due during the moratorium. And then they get until 12 months after the end of the moratorium to repay the balance. And if they do those things, then they can't be evicted by their landlord. Also, under the Santa Clara moratorium, a landlord may not charge a late fee for rent that was due during the moratorium, assuming that the tenant actually repays under this timeline. There's also a federal eviction moratorium. The federal eviction moratorium was originally enacted last year by the Centers for Disease Control and Prevention, and it was extended by order dated January 20th, and that extension took it through March 31st. A new extension is very likely. There's been quite a bit of news discussion about this in the last week or so. So I do expect that over the next week, before the end of March, we will see this get extended again. Probably, my guess is that it'll get extended till the end of June. The federal moratorium, similar to SB 91, only covers residential tenancies. It does not cover commercial tenancies. And the way it works is it allows a tenant to complete and provide to a landlord a CDC eviction declaration form, which certifies that the tenant has been specifically affected by the pandemic and has exhausted all other avenues for help. And there are specific income requirements. In contrast to California's SB 91, a tenant has to meet be below certain income thresholds in order to qualify for this moratorium. And my last point here is that it is not entirely clear that the federal moratorium actually applies in California in light of the existence of SB 91, which is in a number of ways actually a more protective moratorium. I haven't seen that tested yet in a case, but there's been commentary questioning whether it actually has any meaning in California. So that's the end of my presentation. I know it was pretty quick.